Good afternoon, everybody. Thanks for joining us for the 9th OSHA webinar in Conn Maciel Carey's 2017 OSHA webinar series. For those of you who have been following the series and following the upcoming events, you may have noticed a change in the program description for today's event. We were originally planning to talk in September about the new leadership team at Federal OSHA, the new political leadership appointed by the Trump administration. But as you probably know, things have moved fairly slowly on that front, and there wasn't a whole lot to talk about. So instead, we thought it was a good opportunity to revisit what's going on with OSHA's electronic record-keeping rule, because there have been a lot of changes and a lot of developments, and we get a lot of inquiries about this rule. So that's why today, instead of talking about the empty seats at the top at OSHA, we're going to be talking about the electronic record-keeping rule, what things look like today, and what the future may hold for the rule. One of the two faceless voices you're hearing right now is Eric Conn. I'm one of the founding partners of Conn Maciel Carey, and I chair the firm's National OSHA Workplace Safety Practice Group. My practice focuses essentially exclusively on workplace safety and health, legal and regulatory issues. I work with employers to navigate inspections, investigations, and enforcement actions, primarily involving Federal OSHA and the state OSHA programs, but also the Chemical Safety Board, MSHA, and EPA, where it overlaps with worker safety issues. I also handle all aspects of OSHA litigation, from appeals of civil OSHA citations to criminal investigations and prosecutions of workplace safety and health charges, fatalities, and other issues that come up during inspections. And I write and speak regularly on safety and health issues, including as the editor of Conn Maciel Carey's OSHA Defense Report blog. I'm going to let my colleague Dan Deacon introduce himself, and then we'll get into what we're going to cover today.
Great. Thanks, Eric. Good evening, everyone. My name is Dan Deacon, and I'm an associate here at Conn Maciel Carey in both the OSHA Practice Group and the Labor and Employment Group. I represent employers during inspections and investigations conducted by both federal and state OSHA. I also advise and counsel employers responding to notices of employee safety complaints and citations. And on the labor and employment side, I represent and advise employers in all aspects of the employer-employee relationship, including wage and hour disputes, claims of discrimination, and I also work with employers to draft and revise employee handbooks and workplace policies and procedures. So with that being said, I'm going to turn it back over to Eric. He's going to go through the agenda, and we're going to get into the meat of the presentation.
All right, so we're going to be talking today about the electronic record-keeping rule and really the two major components of the rule, both the electronic data submission elements of the rule as well as the new anti-retaliation elements of the rule. We'll spend a little bit of time talking about the current lay of the land, what your current obligations are, which elements of the rule are active, which are not, and what your obligations are under both sets of elements. Then we'll talk a little bit about the future of the rule, what's likely to happen as the Trump administration continues to roll out its agenda. And then finally, some compliance tips for, again, both aspects, the data submission and the anti-retaliation elements. So when I talk about the electronic record-keeping rule, everybody's got their own sort of slang term for what this rule is. The actual official name of the rule is the Improved Tracking of Workplace Injuries and Illnesses. I don't use that because it's a little bit cumbersome, and I think it's a little misleading about the rule, what the rule was really about. And you'll understand my perspective on that as we go through what the two major components of the rule are. I'm going to focus on the electronic data submission components of the rule. Dan is going to talk today about the anti-retaliation elements. So when we say the electronic data submission elements, what we're talking about are these two major provisions, that employers who have establishments, individual workplaces with 250 or more workers whose injuries they're responsible to record present at that establishment, must annually submit to OSHA their OSHA 300, the data from their OSHA 300 logs, the data from their 301 incident reports, and the data from their 300A annual summaries. Certain establishments If you have 20 or more workers at 20 to 249 employees at an individual establishment in certain high hazard industries. And I put quotes on the slide. I'm also, you can't see it, but doing the obnoxious finger quotes because I think the definition of high hazard industry that OSHA has selected in this rule is a misnomer. But the concept here is if you're on a list of specific high hazard industries because your industry, not your workplace or not your company specifically, but if your industry's average DART rate, which is an injury recording rate, days away, restricted work and job transfer rate, is above a certain threshold, that threshold happens to be essentially the national average DART rate. If you are slightly worse than average, you're considered a high hazard industry, or if your industry is. And if you have 20 or 249 employees at an establishment with a NAICS code that places you in one of those industries, you will have to submit to OSHA annually the data from your 300A annual summaries. So let's get into some of the nuances there, and I chose my words carefully when I talked about data and establishments, high hazard industries. What does all that mean? To determine the applicable employee count, whether you are one of these establishments that has 250 or more workers or 20 to 249 workers covered by this rule, to do that count, you count the total employees at peak employment during the year. So at the day of the calendar year where you have the most number of active employees whom your company directly supervises on a day-to-day basis. So it's not about what's on your payroll. It's not about someone who is considered to be your employee on a technical basis. It's about whether you have that number of workers at peak employment who you are responsible to record their injuries. It's an injury to that person belongs on your log as opposed to a subcontractor's log, a temp agency's log, or otherwise. And that's the key determining factor here. Is this an employee who you are supervising on a day-to-day basis, an employee for whom you're directing the means and methods of their work, an employee who you're providing the instrumentalities to perform the work? If that's the nature of the relationship, their injury belongs on your log, then that's an employee you have to count for purposes of determining whether you have 20 to 249 or 250 plus at your establishment. That includes temp workers, seasonal workers, part-time workers, as long as you are supervising them on a day-to-day basis and directing the means and methods of their work. And the key here, and one of the common questions we get is this a company-wide calculation? Is this a workplace by workplace calculation? And the answer is it is tied to establishments, which is a defined term in OSHA's injury and illness record-keeping regulations. An establishment is a single physical location where business is conducted or where services or industrial operations are performed. So typically that means an individual specific workplace. But if you are in industries where you've got remote workers, teleworkers, or a series of mobile crews, there are lots of different ways in the record-keeping regulation that you will establish an establishment for purposes of maintaining a 300 log. The advice that I've been giving to my clients about this is however you define your 300 log territory is how you should analyze the establishment question. So if you have a series of mobile crews that all report out of a single central workstation and you maintain a single 300 log for all of those crews, then that would be an establishment for purposes of this rule. Now the other thing that's interesting about the way the record-keeping standard works is, or the record-keeping regulation works, is there's a little bit of flexibility on how you set up those establishments, particularly in the context of mobile crews, mobile workplaces, construction sites that are not long-term projects. You've got some flexibility in how you define the establishment in that regard, and there may be ways to think about that strategically as it relates to this data submission rule. It may behoove you to establish more establishments, if that can be done legitimately under the regulation, if that brings you down below one of the threshold triggers for participating in the data submission under this rule. So something to look at and think about as well. I see a couple of questions have come in on this specific issue of defining the applicable employee count. One is when establishing the applicable NAICS code, and that's how you determine whether you are in one of these industries. It's the applicable NAICS code for your establishment. Is it fall into the NAICS code that is in that list of high hazard industries? And so in determining the applicable NAICS code, how do you determine that? If you have, for example, in the same building, you've got a retail establishment, you've got a back-of-the-house warehousing operation, and you've got your, headquarters operations with HR and other office administration. There are a couple of different ways that the selection of your NAICS code is determined, and it is primarily an analysis of what is the primary business that is being performed there, and you can look at that either from a revenue basis or I believe I can't remember if it's sort of hours worked by, what is the business function that's being performed and the majority of hours worked there, or by revenue stream. And you get to pick, which one is the right NAICS code if you can justify it. But for a retail establishment that also has back-of-the-house warehousing operations and business functions within the same building, I would say it is very likely that the retail function is the one that will carry the day, and that's the NAICS code that you should use. And that's, I think, a good thing. It's a good and bad thing. I think certain retail businesses are not covered by the record-keeping regulation at all. They're part of the partial exemption list, and you would not have to participate in this data submission requirement if you're not required to keep 300 logs at all. But at the same time, certain other aspects of retail are considered high hazard industries. So depending on which type of retail you're in, you might want to, dig deep and see if there is an alternative NAICS code like the sort of business function, HR function that you're allowed to follow. Certainly the warehousing operation would be covered by the record-keeping rule and a high hazard industry, so you want to do the analysis and focus that way. The question is, another question comes in is, what NAICS code does OSHA use? I mean, OSHA generally is going to ask you, and then they'll verify in their own regard. So you'll present to them the NAICS code that you believe applies, but they will look, the question here specifically asks, do they look at Dun & Bradstreet? What do they look at? I think they'll look at things, yes, like Dun & Bradstreet walking in the door. They'll look at your insurance records to see if your workers' comp insurance records reflect a certain NAICS code, and they're going to ask you which is the applicable NAICS code. And if they don't ask you and there's a dispute about this, you ought to be proactively putting that in front of OSHA saying, look, we are covered by NAICS code X, and here's the reason why. 70% of the revenue or the work function at this establishment is this, and this is NAICS code XYZ, and it's not covered or whatever. And then another question here about unpaid interns. And I actually may ask Dan to think about that question, because it has to be an employee relationship, and an unpaid intern, generally speaking, if you're doing things right and setting up the internship right, where they're basically just shadowing and not actually performing work, I would say that's not an employee, and that would not count towards your applicable count for the 300 log or for coverage under this rule. But I know that there's an issue. Certainly the Department of Labor has been looking hard at mischaracterization of interns and saying, wait a second, this person doesn't qualify to be an unpaid intern, and then you might find yourself in a double jeopardy situation where you're getting a review from the Wage and Hour Division and and OSHA for not following this rule correctly. But if someone is truly an unpaid intern, meaning they're not doing substantive work, and just shadowing, and it's more of an educational function than a work function, I would say that person does not count towards your employee count for these purposes. There has to be an employee relationship. Even if it's not technically your employee, they have to be an employee to be covered under this rule. So moving on, we do get lots of questions about that issue. It doesn't surprise me that we got so many here today. So hopefully we covered all those. If there's others, please do follow up with us. The count issue also requires that location-by-location analysis, just to reinforce the fact that this is not a corporate-wide calculation. This is not about how many employees does company XYZ have. It's about how many employees are covered by the log at a specific establishment. So an individual-by-individual analysis, then determine whether you meet one of the two thresholds, 250 or more, or 20 to 249. And if you're in that 20 to 249 level, then you have to do a NAICS code analysis of that particular location. And the NAICS code, as we talked about from a question here, may be different from your headquarters to various different locations without your business. What is the primary business function at that location? What NAICS code covers that? And is that NAICS code on the list of high hazard industries? That's how you determine whether you're covered by this rule. And the effect that we're expecting to see of this rule, or the effect that OSHA announced of who would be covered by this rule and having to submit data, is essentially a quadrupling of the employers required to submit their injury and illness data to the Department of Labor in some form or another. And the reason why there was any number of employers who were submitting data historically is because there was the old Data Initiative, Bureau of Labor Statistics injury surveys, and the OSHA Data Initiative injury surveys, where historically there were some employers on a rotating basis who were asked to participate in one of those surveys. And there are also employers who, through the course of an open and active OSHA inspection, are having to submit injury and illness data to OSHA. So historically, there was about 38,000 to 130,000 of those large employers, 250 plus workplaces that were submitting on an annual basis some injury data to the Department of Labor, either to BLS or to OSHA directly. And it was always, in those circumstances, just the 300A data, and it was always for just a specific establishment, and it was always a rotating basis. So you weren't doing this every year. It was upon invitation to participate in one of those surveys. I'm sorry, it was about 38,000 who were asked to participate each year. That number is expected now to grow to about 130,000 who would be covered by the new rule, 130,000 of those 250 plus establishments now who would have to submit data every year to OSHA through this new record-keeping rule. So a big jump from about 38,000 to 130,000. The other really, really significant jump is for those large employers who will also have to be submitting those detailed incident reports, the 301 incident reports. That was essentially, zero employers who were required to submit that data to OSHA on an annual basis under these surveys. None of the surveys called for that level of detail, to now an anticipated about 1.3 million 301 incident reports would be submitted to OSHA under this rule. So a massive amount of data that OSHA has not previously collected now being submitted on an annual basis. For those mid-range employers, the 20 employees to 249 employees in high-hazard industries, there were about 160,000 of those establishments that were participating in the various injury data surveys, now expected to jump to over 400,000 of those sites participating and having to submit just the 300A data under this rule on an annual basis. So big, big change in who is now opening their cabinets, lifting their skirts, and sharing all this historically private data with OSHA, data that I'm sure that they would prefer to not have to share with OSHA on an annual basis. And so what is it exactly that employers are submitting? I've been careful to say the data from these logs, because this is not a hard copy submission, which actually is how we used to participate in the BLS survey or the OSHA Data Initiative survey. You would send in physical copies of your 300A annual summaries. This is an electronic data submission. Even if it's from the 300 log, it's the data from your 300 log. If it's the 300A, it's the data points from the 300A, not the actual piece of paper itself. And you're to submit this through, again, obnoxious finger quotes, a secure data portal, a secure website, and we'll talk a little bit about how already in the first 2 weeks of this database going live, there's already been some hacking activity and some great concern raised by the federal government about the security of its own data portal. But it's supposedly a secure website that we're submitting this data to. You may make this a centralized process where a central source at your headquarters does the data submissions for all of your establishments, but there have to be separate individual submissions being made for each individual establishment within the company. So it is not a corporate-wide submission, but it can be done by a single individual. Can set up an account, set up various establishments underneath the account, and submit the data individually for your various establishments that are covered by the rule. OSHA will attempt to scrub employee identifying information. So when we get to the point that we're submitting 300 log data and 301 incident report data, there is individual employee identifying information on those records. Employee names, job titles, descriptions of the injuries that might be self-identifying to the employee. OSHA has explained that they will scrub employee identifying information. I've learned from my friends at the agency that what that means is they're basically going to eliminate the columns on the 300 log and the boxes on the 301 incident report that tend to have employee identifying information, primarily just the name category from the 300 logs. The problem with that is there is, as I said, other information on these logs and in these incident reports that can be employee identifying. And I'm not aware of any effort that OSHA is going to make to mine those other fields, like the description of the incident, the health outcomes of the incident, and in the 301 reports, all sorts of boxes that might tend to reveal employee identifying information. And frankly, with the volume of data that OSHA is expected to collect here, I don't see any way possible that OSHA could actually mine those fields for employee identifying information if they're going to publish the data or otherwise maintain it in a way that we are aware there's some risk of it not being kept secure. So that's a big concern of all interested stakeholders here. Conversely to the idea of scrubbing employee identifying information, OSHA's original intent with this rule, and I say original intent because I'm not sure what their current intent is, and we'll talk about that, but the original intent was to publish the data that employers submitted through this portal for all the world to see, and there would be absolutely no effort to scrub employer identifying information. And frankly, my view of this rule is the entire purpose is to highlight employer identifying information and to use this data when publicized as a method to shame employers, from OSHA's view, to shame employers into changing their conduct, into changing their safety and health programs, to drive down record-keeping data. I think that's sort of a backwards way of thinking about this because your injury and illness record-keeping data was never intended to be, and we know is a terrible metric for evaluating someone's safety and health program because of a lot of the nonsense that's required to be recorded on there. You know, the same day that OSHA published this final rule, they also published an interpretation letter that basically said, it doesn't matter if you determine that an employee was drunk or high when they caused a workplace accident, and being drunk or high was the sole cause of the accident that caused the injury, that is still a work-related injury that needs to be recorded on your log. And that's something now that's going to be used to shame an employer for not having an effective safety and health program. Other things that we know go on logs are things like a slip and fall where there's no workplace condition that contributed to the slip and fall, a bee sting where an employee has an allergic reaction to the bee sting, things that are happening out in the company parking lot, fights, workplace violence circumstances, and these are data points that are going to be used to shame employers when they're not really any indication of the effectiveness of the employer safety and health program. I've got a bunch of questions coming in here, so let's take a look at some of these real quick. Is there a benefit to rolling up the reporting to a headquarters location if you have multiple operations in multiple states? That's a great question. I think I think there probably is some advantage to that in terms of consistency and perhaps putting this operation into the hands of the person or the people at the company who are most knowledgeable about OSHA's injury and illness record keeping, so that there's an opportunity to do analysis of confirming that this establishment is covered by the rule. If the person who's most knowledgeable is making that decision, you're less likely to do, courtesy production of data that's not required. You're also likely to have the most knowledgeable people evaluating the data itself to make sure there's not over or under recording that could create problems both from an enforcement standpoint and the public perception standpoint that OSHA is driving at. And then also, again, thinking about this as a record-keeping issue, the purpose of record-keeping historically, and the reason why I understand and value injury and illness record-keeping, is it is supposed to be a tool for employers to identify trends of workplace hazards so that they can implement improvements. So if you have a central location looking at the injury and illness data for all of your establishments, they might see some outliers and say, this is interesting. Why is this establishment or this small subset of establishments having a much higher injury rate? Let's put some resources to those locations. Now, obviously, that can be done outside the context of this reporting or data submission exercise, but it would be another good way of funneling things to the right people at the company with the most knowledge of the issues, checking for application of the rule, checking for accuracy of the record keeping, and looking for issues where there's opportunities to improve safety and health. But other than that, there's really no special reason that an individual location could not very effectively submit its own data under this rule. But again, it's an opportunity for the corporate level to check that the company is complying with the rule if you've got a centralized location there. Do employers have to set up the establishments? Yeah, we'll talk a little bit about. I think Dan's going to go through the actual portal itself, some step by step. But this is not, will not be self-populated. It will not be. OSHA is not going to notify you that you're covered and send you sort of a link to your setup. You're going to have to set up first sort of the company and then individual establishments within the company for reporting purposes. And it's something that, we as the employer community will have to be, proactively taking these steps to submit the data. Yeah, really good question here comes in about what about the use of alternative forms, like first reports of injuries instead of using the sort of OSHA prescribed 301 form. Does this create any issues for the data submission? I would say no, because the reason is we're not actually submitting the form itself. We're submitting the data from the form. And as a result, if our alternative form, like first report of injury, actually satisfies the definition of an alternative effective form, it will have all of the same data. It might make things a little bit more difficult for you to sort of pluck out the right data to enter into the database, because it won't be as regimented as box 1, box 2, box 3, but all the data should be there. And since we're not actually submitting the forms themselves that you're using, it doesn't create a regulatory problem. It might create a logistical hassle, but it's something to you work through. As you do it the first time, you'll see. I'll also make the point, and I'm about to get to sort of the deadlines for where we are in this rule. In the first year of the rule, when we're about to make our first data submissions in the next few months, we are only submitting 300A data regardless of the size of the company. You know, I talked about bigger companies are doing 300 log, 301 reports, and the 300A data, not in the first year. And my prediction, frankly, is that this rule is going to be changed. And I think that there is a very high likelihood that that one of the changes is that no one's submitting anything but 300A data. So before you go and abandon your alternative forms, let's just keep track of this rule and make sure that there will ever come a time that we're submitting 300 log data or 301 incident reports, because my prediction is that that's not going to happen. All right, let's move on to the next subject here. I've talked a little bit about the shaming aspect of this rule, and from my perspective, that is the only aspect of this rule. It was the motivating factor, maybe the only factor for OSHA's collection of this data. I do not believe that OSHA has any resources to be able to effectively use this data for targeting, for policy decisions, for rulemaking decisions. This is about collecting and publishing to embarrass employers, or as Dr. Michaels said numerous times talking about this rule, to nudge employers to prevent work injuries and to show investors, job seekers, customers, and the public that they operate safe and well-managed facilities. And that's really what this rule is all about. And really the purpose of this rule is to harm employers in those various ways. I mean, Michael's listed the people who will be looking at this data. The idea is that you'll be harmed if it discourages consumers from doing business with you. You know, this is another data point for consumers to look at and say, who's operating safe workplaces that I want to give my business to? And you know, they may be a factor in the decision to not do business with you. Thwarting contract opportunities with customers or other contractors or other potential consumers. Providing ammunition for your competitors and organized labor for organizing campaigns or to be used at the bargaining table to get additional leverage in CBA negotiations. Scaring off current and prospective employees, eliminating access to business loans, driving up your insurance rates and premiums. I mean, this is, you know, I usually when I talk about a big OSHA rule, I talk about the unintended consequences, the thing that OSHA just doesn't think about because they don't run business and they don't think about all the factors that are important in running a business. And it's the unintended consequences that are so harmful to employers. Well, that's not the case here. I mean, these are the intended consequences. This is exactly what OSHA wants to happen, is for consumers to make decisions about your injury and illness rates, to have employees and prospective employees make decisions about your rates, to have plaintiffs' attorneys have available to them data that allows them to target and to use as evidence in cases against companies and industries. So it's, you know, the intended negative consequences here. The real interesting thing about this rule is this was, you know, an Obama-era rule that the Trump administration is grappling with now. And so there is a relatively long rollout period for this rule that has been changing. So let's talk about the current year. And the current year, look under 2016. I know it's 2017. I finally started updating that on my checks. But the idea here is that we're going to be reporting the injury data from 2016, from calendar year 2016, in 2017, submitting it to OSHA. And in the original rule, the original deadline, I believe, was July 1st for the data submission, first data submission for your 2016 data. That deadline was pushed by the Trump administration when they first walked in the door to evaluate the database itself, to evaluate whether they wanted to keep the rule, whether they wanted to make changes to the rule, and to give an opportunity for the new administration to really think about the future of this rule. They pushed it originally indefinitely. It was a delay from July 1st. That date just disappeared and there was no new date. They did eventually identify a new date, and that is December 1st. So as we stand here today, the date for employers to submit, employers covered by the rule, one of the two threshold levels of employees, to submit their 2016 injury and illness data is December 1st, 2017. And I expect that's probably going to stick. I do anticipate, and we'll talk about changes to the rule in the future, but I'd be surprised if those changes happen before December 1st. So I think we can expect we're going to submit some data on December 1st or by December 1st. And in that first year, as I mentioned, regardless of the size of the employer, you're only submitting your 300A data. So even if you have an establishment with 250 or more employees, you are not required to submit 300 log or 301 data. And in fact, I don't think the database is set up to accept that data. So even if you were trying to, I don't think there would be a way to do it. But right now, we're focused only on 300A data in this first year. In the second year, for 2017 injury data, the logs that you're making entries into right now, when we get to 2018, by July 1st, 2018, you'll be submitting that data to OSHA again unless the rule changes or is rescinded. And in that year, you'll be submitting the, if you're one of the larger establishments, the full 300 log data, 300A data, and 301 incident report data unless the rule changes. And then going forward, 2018 data and thereafter, beginning on March of 2019 and March 1st of every year thereafter, that will be the new deadline under the rule, which sort of jives with the, you've got your calendar year ends, then you've got a couple of months to develop your 300A data, to publish it at the workplace, and then in the next month after you've published your 300A in the workplace, you're then submitting the data to OSHA. So a couple of questions here. Does the individual establishments within a company or a corporation roll up so that OSHA can see the overall big picture for the entire organization? That's a really, really good question, and my expectation is the answer is absolutely yes. The way that you sort of set up the establishments is they link back to an individual company or an individual employer. So I think the database is configured to link those establishments. And likewise, my expectation, my view of what this publishing of the data looks like is it is in a very user-friendly, so to speak, fashion where it is sortable, searchable, filterable, downloadable, exportable, so that you can do all sorts of things to, pull together data for employers under the same NAICS code, to pull together data for all the establishments for an individual employer, or all the establishments in a specific state for the employer, and to be able to use it in all those ways that we know OSHA wants it to be used to harm employers' interests. So I think absolutely it will be, if they publish the data, everyone will be able to do what you asked about. If they don't publish the data, at the very least, OSHA will be able to do what you've asked about because they do link the establishments back to companies. Good question here about state plan states. We'll talk about that later on in the program. State plans are required to adopt the rule, but they've got some leeway in how they implement it and when they implement it. We'll talk about that in some detail. All right, let's see what else we got here on the data submission parts of this. Just the current lay of the land. The rule was challenged in federal district court. A preliminary injunction was sought to prevent OSHA from implementing the rule. The PI was denied, but ultimately that case was stayed, essentially because the new administration said, instead of litigating whether the rule is legal, let us wrap our heads around it, analyze whether we want to keep it or keep it in its current form, and then if we change the rule, if we rescind the rule, the case is moot. If we change the rule, let's see whether a legal challenge is still necessary and make sure we're challenging the right thing. And if we keep the rule as it is, we'll restart the case and let these stakeholders challenge the rule. Some other interesting things that happen, the FAQ page, now whenever OSHA issues a new rule, they have an FAQ page that sort of helps interpret, the first wave of interpretations of the rule. Well, that FAQ page had a couple of questions and answers about the publishing of the data. Shortly after the Trump administration took the reins, those FAQs related to publishing of the data disappeared. So there was no active statement by OSHA that said we're no longer intending to publish the data, but those FAQs disappeared, which sort of signaled that they're either not going to, they're analyzing whether they can not publish it, or it's at least in question whether they're going to publish the data. we've done some research on this, and we've determined that there are perhaps some backdoor ways to force OSHA to publish the data. So even if OSHA says we're not going to publish it, and industry has impressed on OSHA hard that we don't want this data published, there may be a way under the Freedom of Information Act that if, I think it's 3 or 4 separate resources, separate people, separate stakeholders, FOIA the same data from a regulatory agency, the agency is required to publish the data. Now, in what form it's published is a very different story. Rather than the user-friendly version that I've had my nightmares about, we could see just a raw data dump that's a whole lot harder for people to use and to understand. So if they're forced to do it against their will, OSHA may choose to publish it in a not-so-user-friendly data, but all that remains to be seen. We've already talked about the new deadline to publish the data this year. The database itself was slow to go live. It did go live on August 1st of this year, and we know that some employers have rushed to be the first to submit the data. I think that's a bad idea. We'll talk about that at the end of the program, but it is live, so an opportunity for you to go check it out, evaluate how you set up the account, and get familiar with it. But again, I would not start entering the data yet. Let's take some time on that. I'm going to let Dan take over here and talk about the database itself, the portal, and then get into the anti-retaliation elements.
Great. Thanks, Eric. Just following up on a prior question about unpaid interns and whether they are included in the employee count, the answer to that is no. Under the OSHA Act, the term employee is those who are employed in a business of his employer which affects commerce, and an uncompensated intern or a volunteer is not going to be considered an employee under the Act, so they are not included in the employee count. Moving on to OSHA's injury tracking application, I'm just going to talk a little bit about some of the details of the application and the questions that have been raised by it. Many of you may not have familiarized yourself with the app at this point, but we're coming closer to the December 1st submission deadline, so we've got a lot of questions coming in about how it should be filled out and who exactly needs to submit the data. I know someone raised a question about state plan states. I'm going to touch on that in a couple slides here. So first, I'm just going to go over some of the concerns about OSHA's injury tracking application and the electronic submission of the data. And Eric kind of touched on this a little bit already. But the number one concern that we've heard from employers is the privacy concerns. The application was hacked about 2 weeks after it's launched on August 14th, 2017, and OSHA had to shut down the site pending an investigation, and it took them 2 days to shut down the site after being notified by the Department of Homeland Security of a compromise of user information. And this kind of validates the long-standing concerns that were raised in the rulemaking about privacy and protection of confidential and personal health information. OSHA, as Eric mentioned, states that they intend to scrub employee identifiers, health information, and confidential information, but the recent hack doesn't sound promising in that regard. What happens if that information is hacked prior to being scrubbed? Is the application going to scrub the information prior or simultaneously when it's submitted? Perhaps this isn't an immediate concern this year, seeing how employers only need to submit 300A data, but it's certainly a concern going forward. And if OSHA does decide to shut this application down or rescind the rule, this event could be one supporting reason to support that rescinding the rule, or at least shutting down the electronic data submission. The second concern here is the vague and confusing submission instructions that they have on their website. There's a couple of different ways employers can enter data into the application, either manually or in a batch, but the instructions aren't very clear. I mean, there's multiple different links on the application web page that consist of multi-page instructions that you kind of have to parse through and piece together. And the instructions often use terms that aren't precisely defined, and that it could potentially cause employers to fill out the application incorrectly or submit the data incorrectly or more than what is required. And third, finally, it's still unclear what OSHA is going to do with this data. As Eric mentioned, the rule quadruples the number of employees submitting data. And given the cuts to the budget that'll be coming, it remains to be seen how resources are going to be allocated to support this effort, if at all. Perhaps there could be some type of targeted enforcement, but it remains uncertain at this point. Also, it doesn't appear that the data is going to be published on the website. As Eric mentioned, that language was removed from the FAQs, which is somewhat of a reprieve for employers, but the public may still be able to get that information to the normal FOIA channels. So on this slide, I just want to go through what I've outlined as the three-step process to submitting the data. And by listing these three steps, it may seem fairly easy, but in that respect, it isn't. First, you're going to need to create an account and login information. Here, off the bat, it gets a little confusing. It asks in the creating account and the login information for the company name field. And we've gotten a couple questions about what company name should you use. And the answer to that is the entity that actually provides day-to-day supervision. They are the ones ultimately responsible for maintaining the record-keeping forms, and that is the company name that should be used. The corporate entity, it gets a little more confusing when you're creating an establishment, because under that, it asks for an establishment name and a company name. And under the company name field, there's an asterisk which states to identify the name of the company that owns the establishment. And this is a little tricky because the owner of the establishment may very well be different from the company responsible for that's submitting the data. Think of a franchise situation. Note that you're not required to complete this field, though, and we don't suggest that you do so. You don't need to provide any more information than what is required. So the second step is going to be deciding between manually entering the data or submitting it as a batch. And you can use the manual data entry if you want to do this manually through the computer through a series of web forms. You're going to first create an establishment and add your first establishment to the system. And once you create that establishment, you open it to submit the 300-day data, and then you can submit it. For the batch data transmission, you can insert data for multiple establishments at one time. And you begin by clicking on Upload a Batch, which is going to direct you to a file upload page. And there's certain templates and forms that instruct you on how to complete the forms that you'd need to upload. It's pretty detailed instructions, and it's going to take a lot longer than the 10 minutes per establishment that OSHA identified in the preamble, in the final rule. But that is an option, and it may be easier to facilitate if one person is submitting on behalf of multiple establishments. So here's a question about state plan states. State plans are required to promulgate injury and illness recording and reporting requirements. With respect to the data submission requirements, they have a little bit of leeway on how to collect injury and illness data. States can allow their employers to use the Fed OSHA portal, or they can provide their own data collection sites. Most states at this time are opting to use OSHA's Fed OSHA's portal, but not all states have updated their record-keeping requirements yet. They have to go through their own legislative process to finalize this, and many of them are not complete. So if you're in a state plan state and you're unsure whether you need to submit data by the December 1st, 2017 deadline, you should just reach out and we'll provide you that answer. We didn't think it'd be good use to go through each state at this time for purposes of this webinar, given the host of other information that we need to get through. So now I'm going to jump into the anti-retaliation elements of the rule. And first, I'm just going to start out with what do employers need to do. So as of December 1st, 2016, employers were required to, 1, inform employees their right to report workplace injuries, 2, of their right to report work-related injuries free from discrimination or retaliation. And note that these first 2 bullets here can be done by posting the workers' rights poster in the workplace, which can be found on OSHA's website. And 3, employers needed to update injury reporting policies to remove unreasonable elements that may discourage employees from reporting. And these elements were responding to universal criticisms and complaints that the rule would lead to underreporting and underrecording. So OSHA supplemented the rule to include elements about employers' practices that discourage and retaliate against employees for reporting those injuries. Prior to getting into some of the specifics of the rule, just for your reference, I want to highlight OSHA's guidance on these issues that are worth reviewing if you haven't done so yet. OSHA issued a guidance memorandum on October 19th, 2016, addressing to some degree what OSHA intends by reasonable reporting procedures, and specifically what type of employee discipline, post-incident drug testing, and safety incentive programs were considered retaliatory and therefore violative of the rule. Additionally, during the waning months of the Obama administration, just about a week before the inauguration, OSHA took even further steps to insulate its efforts to combat retaliation, issuing guidance titled Recommended Practices for Anti-Retaliation Programs, and that came out January 13th, 2017. It was intended to help employers create effective anti-retaliation programs for the workplace, and it identified 5 key elements: management, leadership, commitment, and accountability; 2, a system for listening to and resolving employee complaints; 3, a system for receiving and responding to reports of retaliation; training; and 5, program oversight by management. So I recommend taking a look at both of these guidance documents, as they've been instructive in interpreting the rule and some of the vague provisions that we see in the preamble. Next, we're going to talk about reasonable internal injury reporting policies. The rule added paragraph B14 to 1904.35 to prohibit retaliation against an employee for reporting a work-related injury. And this is a prohibition already explicit in Section 11C of the OSHA Act itself. However, under the text of the rule, an employer can be cited just for having a policy that has a retaliatory effect. Now, based on the interim enforcement memo that was issued in November 2016, we know that this is not true. A whistleblower is required, and I'm going to get into that a little more in a couple slides. However, there must be some form of a complaint from a current or former employee for OSHA to bring an enforcement action under the anti-retaliation provisions at this time. So the first bullet here, OSHA can cite employers for implementing policies with a perceived retaliatory effect for reporting workplace injuries, and that's discipline for late injury reporting and discipline for violating vague safety rules, both. So the rule doesn't define reasonableness. Again, employers need to have reasonable reporting procedures. OSHA didn't explain what reasonableness meant in the rule or the preamble. The preamble did, however, make clear that a policy that either requires immediate reporting of an injury or that creates an undue burden on employees to complete a report violates this new requirement. Additionally, the discipline for violating vague safety workplace safety rules, such as work safely, as you see on the screen here, or maintain situational awareness, are going to be scrutinized closely, and especially if it's only dished out after an employee injury is reported. From that October guidance, we got a little more insight into what OSHA means by reasonable reporting procedures. For example, reporting policies with hard reporting deadlines are going to be scrutinized closely because they may deter employees from reporting. For example, report within 24 hours or face discipline. Additionally, it's not reasonable to discipline employees for failing to report an injury before they realize they have a reportable workplace injury, or when they're incapacitated. Employers can, however, implement policies that require employees to report a work-related injury or illness as soon as practicable after realizing they have the kind of injury or illness that they're required to report, such as the next business day. So the key inquiry here is whether the employer's policy provides some amount of time to report after the employee has realized he or she has suffered a reportable workplace injury or illness. All right, post-incident drug testing. This is a lot of, or we get a lot of questions about this topic. The rule snuck in provisions related to post-incident drug testing, stating that post-injury drug testing may dissuade a reasonable person from reporting a workplace-related injury. The ultimate message here is that post-injury drug testing, post-incident drug testing cannot be used as a form of discipline. So one thing is certain about the rule, and that's the second bullet there. Blanket post-incident drug testing is impermissible. However, as you can see, there's several other types of drug testing that is still permitted under the rule. One, pre-employment and random drug testing. Two, drug testing to comply with state or federal law, such as Department of Transportation mandatory post-accident tests. Three, when it's required by workers' compensation insurers, including premium reduction policies for post-incident drug testing. And five, finally, post-accident incident drug testing is permissible if the employer has a reasonable basis to believe drugs or alcohol contributed to the accident. So this can be used as a tool to evaluate the root cause of a workplace injury. Remember, the rule only prohibits drug testing employees for reporting work-related injuries without an objectively basis for doing so. So to be compliant, there needs to be a possibility, a reasonable possibility that drug use by the reporting employee was a contributing factor to the reported injury. There need not be reasonable suspicion, and there's a distinction here. There need not be reasonable suspicion of drug or alcohol use in a specific incident, just that drugs or alcohol are a reasonable cause for that type of incident. Finally, safety incentive and compensation programs. The October memo actually provides further guidance on how compensation programs can operate properly. What OSHA is mainly concerned about here is the chilling effect on an employer's safety and incentive programs. In other words, incentives that would deter employees from reporting a workplace injury or illness. So if we just go through the screen here, you can see with the thumbs down, those are going to be types of safety incentives that are impermissible, and the thumbs up are the types of incentive and compensation programs that would be permissible. And the key here is that if the rewards or bonuses are based on injury rates, it's not going to be permissible. In contrast, if it's based on compliance with legitimate workplace safety rules, that is going to be permissible. And with respect to executive compensation and bonuses, the last two on the screen here, there is a little leeway. As you can see, those last two examples, they differentiate between frontline supervisors and senior managers or executives, the front office employees that are somewhat removed from the typical operational employees. A frontline supervisor is going to be more closely scrutinized because of that closer nexus to deterring injury and illness reporting. The executives, senior managers, and the front office people, those types of employees are sufficiently removed in some respects from deterring reporting. And with that being said, I'm going to touch a little bit on some of the other guidance that's out there on the safety incentive and compensation programs. Mainly the 2014 VPP Policy Memo. If you take a look at this, this is posted on OSHA's website. OSHA, in that memo, basically reflects on executive management and supervisor compensation and provides them with a table of the actions to be taken depending on the incentive program structure and the types of employees at issue for that type of program. So the record-keeping rule still raises many questions about the validity of these bonus programs, but the key here is this is not a new issue. Not a new issue for OSHA. It dates back to 2008 in a report issued by the House Representatives Committee on Education and Labor, where they discussed this issue. OSHA's 2012 Fairfax Memo, the agency further condemned these types of practices and incentive programs that have the potential to dissuade workers from reporting injuries. And then finally this 2014 VPP Memo, which ultimately culminated in the mentioning of safety, incentive, and compensation programs in the preamble to the final rule here. So if you have questions about safety, incentive, and compensation programs, it's worth it to take a look at these other guidance documents that I mentioned because they're still relevant and they provide further information on how to set up a proper compensation program. And if you take a look at the screen here, you'll get a flavor of what OSHA will be and is looking at in evaluating those types of programs. So with that being said, final slide here. OSHA issued an interim enforcement memo on November 10th, 2016, in which area offices are directed to refer cases involving anti-retaliation provisions to the Whistleblower Protection Program. Again, I mentioned earlier that OSHA is only going to open an investigation if there's a complaint by a current or former employee. And furthermore, this guidance directs investigators on how to analyze the potential violations of 1904-35. It instructs investigators how to prepare a memo of the investigation, in other words, the merits of the complaint, and the types of recommendations of remedies and damages that are available and when appropriate. What the guidance doesn't do, however, is really address employer policies that have a retaliatory effect, which is actually contemplated by the rule itself. I mentioned that earlier. Nonetheless, even though a whistleblower is technically required under this interim enforcement memo, it's still good practice to make sure your policies do not have a retaliatory effect, thereby limiting any potential for a future whistleblower complaint.
All right, so we'll talk a little bit here at the end of the status of these anti-retaliation elements and then the future of the rule in all those regards. The anti-retaliation elements are in effect. The rule became effective last year. The rule itself is in effect all around. We just haven't come to the first deadline yet for the data submission. The anti-retaliation elements have been in effect. They have been the law of the land now for several months, and OSHA is out there doing inspections and actively pursuing violations of these anti-retaliation elements. The thing that's weird about this anti-retaliation rule is that OSHA has always had a statutory ability to prevent retaliation for taking protected actions like reporting an injury. And I say statutory because it's under the OSHA Act itself. There is a whistleblower provision, Section 11C of the Act, that is enforceable when a whistleblower makes a complaint that they have been aggrieved and they are seeking help from OSHA to remedy that adverse employment action that they received. This new rule is a regulation, meaning OSHA can just issue citations, and they can issue citations whether there's a whistleblower or not. But the way OSHA has been operating under this rule is they're only issuing citations, they're only pursuing investigations, as I understand it, when there is a relator, when there is an employee or now former employee who feels like they've suffered an adverse employment action as a result of something in the injury and illness record-keeping realm or the reporting of an injury realm. We are aware now that OSHA has issued its first set of citations under this rule. It's just happened in the last month. And there's more than a dozen active inspections where this issue, whether the employer has a unreasonable reporting policy, is an issue in the inspection. So it'll be interesting to see how this evolves, how OSHA is using it, what they're doing in terms of abatement. Is abatement, thinking about a guardrail that's missing a mid-rail, abatement is to put the mid-rail on there. If you've got an unreasonable policy, is abatement reinstatement? Is it back pay? Is it changing your policies? Is that something that OSHA can lawfully do through a regulation? It'll be interesting to see how the law develops in that arena. We talked about the legal challenge to the data submission aspect of the rule. Also, a similar legal challenge to the anti-retaliation elements filed in federal district court. That one was litigated pretty far in the process. Obama's Department of Labor filed a motion to dismiss the legal challenge, defending the rule, I think in like the final 2 or 3 days of the Obama administration. The Trump administration withdrew that motion to dismiss and basically agreed to stay the legal challenge for the same reasons we discussed before about analyzing whether they want to keep the rule or amend the rule. So what's the future of this rule? We know from OSHA has made so many signals now by the new administration that they are going to take a hard look at the rule and perhaps rescind it or change it, both as they delayed the first deadline to submit the data, as they withdrew their motion to dismiss, additional briefing and issues in the litigation signaled that. But the clearest signal, I think, came when the Trump administration issued its first regulatory agenda, and this lays out the regulatory priorities and rulemaking priorities for all of the executive agencies under the Trump administration. And the first agenda included the OSHA priorities, and one of the rulemaking initiatives, actually 2 of the rulemaking initiatives in the first reg agenda related to this e-record-keeping rule. The first one was to authorize the changing of the deadline for the data submission, and the second was to essentially reopen the rule to analyze whether they intend to rescind it or amend it. And that hasn't happened yet. They haven't published in the Federal Register the reopening of the rule, but we've now seen in multiple different places OSHA's expressing that is the path they're going to take. So here's my guess. These 4 bullets here are my guess, my prediction as to the types of things that may change under the rule. And obviously the first one is it's conceivable that the rule is just rescinded. That's not the record-keeping rule. We're still going to have injury and illness record-keeping. They're required by statute to do that. But it may be that this data submission elements and these anti-retaliation elements are just completely rescinded. We go back to the record-keeping rule as it existed prior to publishing the final rule last year for electronic record-keeping. I think that's not the most likely scenario. I think more likely are some tweaks to the rule, and those would include, in my opinion, something like restricting the data that is to be submitted to 300A annual summaries only. Right now, in the first year, that's all anybody's going to submit, but after that, the larger employers were going to submit 301 data, 300 log data, and the 300A annual summaries. My guess is the development of the portal has developed as far as it's going to, and it only will accept 300A annual summary data. I expect that the rule will change to say for everybody, we're only taking 300A data. There's a lot of reasons for that. It doesn't have employee identifying information. It doesn't have a lot of the detail that employers, industry does not want to see turned over to OSHA. It's simpler. It's more in line with the data initiative and the BLS surveys that have always been done. So I think if OSHA is going to continue to collect data, it's probably going to be limited to that 300A annual summary data, regardless of employer size, regardless of establishment size, regardless of industry, regardless of the year that we're in. I also could see some changes to the scope of the rule in terms of the employers who are covered. The large employers are going to be covered by this rule to the extent it exists. Those smaller employers, I could see some changes to the trigger for who's covered. For example, I think they selected a really, really inappropriate threshold for high hazard industries. They're basically saying everybody who is average and worse is a high hazard industry. I think there are more appropriate levels for them to select, which would wipe out a lot of NAICS codes, wipe out a lot of industries. If they set that trigger, for example, at the old high hazard industry threshold they set for the site-specific targeting inspection program. This was already a defined term in the OSHA universe, and they redefined it and reset it at, I think, an absurdly low level. So let's limit this to really the high hazard industries. Likewise, I could see a change in the number of employees. For that mid-range, that 20 to 249, maybe that gets bumped up to 100 and above, and we get rid of a high hazard industry concept altogether and just say if you have 100 or more at an establishment, you're covered by the rule. I could see changes like that to reduce the number of employers and workplaces covered by the rule. There's a question earlier about, is there a list of NAICS codes that are covered for those 20 to 249 employees? There absolutely is. In the rule itself, there is they call it, it's not an attachment, but an appendix to the rule that lists the specific NAICS codes that are covered. You can find that on OSHA's website. If you want, just shoot me an email after this and I can send you a link to it. Or if you check out our blog, most of the articles, and we've written a lot of articles about this rule, will have direct links to it in there as well, so you can check it out there or just shoot us an email. The other big change I think is very possible is that they'll just eliminate the anti-retaliation provisions entirely. It is a vague, general written provision. I don't think it's necessary. I think it's entirely duplicative of the statutory whistleblower provision that already exists, and it's caused a lot of heartburn for the regulated community. And the Trump administration is, a little bit more open to hearing about the concerns of industry. So I would not be terribly surprised to see those provisions wiped out completely. And there's justification for it if they needed to, and they will need to through the Administrative Procedure Act, justify a change in the rule. And the justification from my perspective would be this already exists. It is already unlawful. There's already legal consequences to retaliating against an employee for taking a protected safety action of reporting a workplace injury. So with that current and future lay of the land, let's just cover a couple of quick tips and then we'll let you guys get on with the rest of your day. Some things that I think employers ought to do now and in the near future to deal with this rule. First is provide refresher training on record-keeping requirements. The landscape of record-keeping enforcement changed a lot over the last few years. The Volks case from the D.C. Circuit, the Volks rulemaking, and then the Trump administration repealing the Volks rulemaking to eliminate the rule that would turn record-keeping violations into continuing violations, meaning OSHA can cite you for 5 years, record-keeping violations dating back 5 years is off the table, and I think it's off the table permanently now. So OSHA's hands are tied in how they enforce record-keeping to only injuries that occur within a 6-month period of OSHA's conduct of the inspection. So it makes it hard for OSHA to find and cite record-keeping violations now. And in fact, after the D.C. Circuit decision in the Volks case, record-keeping violations dropped by 70%. So it became very difficult for OSHA to enforce its record-keeping rule. Well, now, if you're publishing your data, you're handing over your record-keeping data to OSHA, it gives them a new opportunity, a new tool to catch record-keeping violations in a more timely way. So it's important to make sure your record-keeping mechanism is working correctly, that you're recording injuries that need to be recorded, that you're recording injuries correctly, because OSHA is now going to have access to your data on a more frequent and more sort of proactive basis. So provide training. Make sure that the people within your organization who have responsibility to maintain the logs are doing it correctly and they understand the requirements. And also that they understand the requirements of this rule, so that you're not submitting data you're not required to, that you are submitting the data that you are required to on a timely basis. I would recommend at this point that every year before you submit your data, you undertake an audit of your injury and illness record-keeping forms. That could be done internally, could be done with a third party, but I think it's a smart move to audit your injury and illness or record-keeping records so that you're only submitting accurate data, so that you're not opening yourself up to enforcement risks, and also not opening yourself up to more shame from the public shaming that this rule is intended to drive by over-recording. So it's important to make sure you're recording accurately. The best way to do that is through audits. And then because of these anti-retaliation elements, you've got to take a hard look at your policies. And remember, these are not, as Dan described, these policies that are implicated by the anti-retaliation rule are all over the place. They're not going to be labeled as internal reporting policies. I mean, there's going to be at least one, hopefully, that has a name like that. But this is out there in your HR policies, like your discipline policies, your drug testing policies, your compensation structure, your compensation calculations. All of those things could be implicated by this rule. So you've got to make sure that you're doing an analysis of your various HR, compensation, safety policies and programs to make sure that you've not run afoul of these anti-retaliation policies unless or until this rule is changed. So that means looking at those policies and updating them as necessary to make sure that they do not create a perception of retaliation for reporting of injuries and illnesses. A couple other things. I highly recommend not being one of the first employers to submit your data in the new database. It's not due until December 1st. The lay of the land on this rule is changing. It's changing a lot. Deadlines have been changed. What may be required to be submitted may change. I wouldn't be shocked to see, the agency change again, either a deadline or say we're not going to require the data to be submitted. Legal challenges may come in. Injunctions may become relevant. And, they're still tweaking the database. I think we talked about the hacking incident that's already occurred in the first 2 weeks. Let's hold off, not be one of the first employers to submit the data because we still don't know what's going to be required of us, by when, and who else's eyes, how many Russians' eyes are going to be on this data. Let's just wait. November 28th, 29th, seems like a good time to submit the data when we know exactly what the lay of the land is and some of these bugs and kinks in the system have been able to be worked out. If you are concerned that you're having to eliminate some of your drug testing, to me, I'm very disturbed by the idea that OSHA is cracking down on drug testing in the workplace at a time where we've already established that there is a national drug addiction crisis in this country, and drugs are in the workplace. Employees are working under the influence of drugs, and OSHA is now trying to make it harder to ferret that out, which to me is the exact opposite of what our safety agency should be doing. They should be encouraging more drug testing and making sure the drugs are not, causing hazards in the workplace. But this rule does impact a little bit, or perhaps a lot, depending on your operations, your ability to test for drugs in the workplace. It does not, however, affect at all your ability to do random drug testing. So a lot of my clients who have had to restrict some of their drug testing policies have increased the use of random drug testing, something to consider to be able to continue to undertake that operation. Likewise, confer with your workers' comp insurer. OSHA says that you're allowed to do blanket drug testing if that is a condition of a policy program that you have engaged in with your workers' comp carrier to benefit from reduced premiums. Talk to your insurer about whether that option exists, and if so, you win-win. You get to continue your drug testing and get a policy premium. So look into whether that's available to you and consider that. Post the latest version of the OSHA Rights poster. I think it's like a 2011 is the version, and OSHA has said already in guidance that if you post that, you've already met one of the key elements or two of the key elements of the new anti-retaliation rule, that you have, by default, by posting this, you have met the requirement to notify your employees about their right to report injuries and their right to be free of retaliation for doing it, because the poster says those exact words. And then finally, for heaven's sakes, please hide those empty pizza boxes when OSHA shows up. Heaven forbid they should learn that you're sharing pizza or barbecue or a cookout with your employees for a good period of safety performance. That is the example they always give of what would be considered an unlawful incentive program. I think that's crazy, but look out for those types of incentive programs and address those. We've gone a little bit over today, so I appreciate everybody sticking with us. I'll encourage you again to please check out our blog, the OSHA Defense Report, especially on an issue like this electronic record-keeping rule where the landscape is changing constantly. We are trying to keep everybody updated on the blog. We're working on a post right now about the state plan states that will be covered by this, so hopefully we'll have a table up there within the next couple of weeks that shows what the different state plan states are doing with this rule and about delays and anything else like that. Also encourage everybody to stick with us the rest of the year for the OSHA webinar series. We've got a few good ones left, and we'll keep after that and hopefully continue this again in the future. I hope you can join us for more of these webinars. It looks like there's a couple more questions. I'll try and tackle a couple more. If we don't get to your question, please do send us an email, reach out, and if you think of a question after today, please don't hesitate to reach out. We'd love to be a resource for you on these issues. I think there was a question, I don't know if, Dan, you addressed it, about the difference in the two compensation schemes, why one would be more preferred and one would be less preferred. The difference is how close the person, how close the supervisor is to the individual employees, because OSHA's view, and I think this is fairly legitimate, is the closer you are to the employees, the easier it is for you to influence the atmosphere, the easier it is for you to chill the atmosphere of reporting. And if you're at a corporate level and you don't have direct interaction with employees, you're less likely to be able to sort of indirectly discourage them from reporting. So that's why there's a difference in treatment of compensation schemes on the incentive program issue there. I think we'll have to dig through to see if there's any other questions, and if we see one that we haven't addressed, we'll follow up with you, or please do follow up with us. Our contact information is right here. This has been, as always, a really interesting topic. Lots of good questions. That's what happens when new rules are promulgated and they're changing. So please don't ever hesitate to reach out to us if you have any other questions. And thanks so much for joining us. And we look forward to visiting with you again at our next webinar, if not sooner.